everyone, and welcome back to my channel. I hope everyone is having a wonderful Tuesday. I know I am, so I wanted to get on a video. So this one, I wanted to do this one. I was going to do another one on somebody else, but Chilli did upload a new video where he's talking about how a police officer cannot trespass you or solicit a trespass. So it kind of goes along with the video I did yesterday. In this video, he also tries to state out case law that he gets wrong on each and every one of them, and I will be able to point out where he's wrong. So with that, I hope you enjoy the video.
Let me say hello to everybody. What's going on out there in the land of YouTube? What's going on, YouTube-ease? I'm YouTubing with you right now. So listen, a couple things real quick house cleaning, and then I'm going to jump right into that. It is a federal offense for police to charge you with a crime if you solicit a trespass, and charge you with a crime if you are engaged in a First Amendment activity. Wrong, 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 wrong. You're wrong, you're wrong, you're wrong. Say, is what this guy says true? Is what he's saying true? Well, let me just tell you something. What I'm about to lay out for you guys, it is a federal crime for police to solicit a trespass against you if you are engaged in a First Amendment right protected activity. And this News Now ninja recently arrested while he was engaged in a First Amendment protected activity. He was charged with interfering, though, and not trespassing. So, and then the second bit of house cleaning is this. If you guys have not heard of this group, these folks, this entity created a way for you to be able to file litigation against the government. And the very beginning steps of setting up your lawsuit. I would love to be able to take any credit for this, but I can't. I can only be a conduit, a mouthpiece for Auditors United. If you guys, you never heard of them before because they're a covert, quiet, anonymous group that doesn't want to be known. I have the
Covert, quiet, and anonymous are actually three words that you could never use to describe an auditor or / a frauditor. Chilli. Again, it is not a federal offense for an officer to solicit a trespass. You can't teach anyone constitutional law until it has been taught to you first. You haven't learned it, you can't teach it. Every time you throw out a case law, you're wrong about what you're saying it means. I keep proving that to you. I have proved you wrong in each and every video that you have put out quoting some kind of case law. You have no clue what you're talking about. You may read it, but you don't know how to comprehend it. It's funny how you actually still believe that you're an auditor, because you're not an auditor. The auditing community doesn't even want anything to do with you, except maybe News Now Homeless, because, well, yeah. You guys share that half brain cell that you have. And if this group helped you file any of your lawsuits, then they're not credible to help anybody else because, you keep losing.
Name Auditors United. If you've never heard of them before, you're about to find out. This entity has put together a structure for you to have a step-by-step tutorial in filing your lawsuit. It's incredible what Auditors United has done. Okay, so I'll introduce you to them very, very soon. I have to make a couple videos showing the process of what these guys have created, and then I'll share it with you guys. So now in the comment section of the video that I just posted, I have received, let me turn the car off. I've received just dozens and dozens, and only one person who, that I shared research with He got it exactly correct in the comment section. But let me read this for all y'all out there who say, "Oh, Chilli's dumb. He's a big dunce cap." Okay, I'm a great big dunce cap. You guys can look this up and you tell me if I'm incorrect. Again,
So I did look it up, and Chili, as usual, you are not correct. Also, Chili, you are not a dunce cap. Don't attempt to insult yourself in that way. You are the dunce. You're the actual dunce that the hat sits on top of, which makes it a dunce cap because it is a hat sitting on top of a dunce. And you are the dunce.
entity that I'm working with that I'm proud to be a part of. These guys are putting together some good stuff for the people, incredible stuff for the people. Wait till you see what we have coming out. It's incredible. Incredible. So with Charlie,
Oh
sorry
my
about that.
god.
Okay, is it like that? Charlie distracted me. Charlie with the bow tie, so cute,
Blame
so
the dog.
amazing. Charlie, little bear. Okay, so now let me read this to you guys so that I can get this out crystal clear. I really wish I had brought something, but I'm just annoyed with the comments. I'm annoyed with people who don't take the time to do the research. So let me just read this. If it's, come on, baby. Come
Oh, poor
on.
Charlie.
Oh, there you go. Okay, so let me read this for you guys. Now, if you are a First Amendment auditor or you are someone who's filming police in a parking lot somewhere and the police try to solicit a trespass against you, it's illegal. Let me read exactly what we
Nope.
have written down here to share with you guys. So all of you dunce caps, I'm so sorry, Charlie. Sorry, baby. All you dunce caps in the comments, it's illegal for cops to solicit a trespass against you while you're engaged in activity.
Nope.
It is not legal for police to solicit a trespass of someone engaged in a federally protected activities. The First Amendment of the United States Constitution guarantees the right to freedom of speech, religion, press, assembly, and the right to petition the government for redress of grievances. These rights are protected by federal government, and police are bound by the Constitution to uphold these rights.
He's cherry
Police
picking.
officers are prohibited from using their authority to interfere with or inhibit a person's exercise of their First Amendment rights. This means that police officers cannot use their authority to encourage or solicit someone to commit a trespass against someone engaged in a federally protected activity such as peaceful protest or picketing. It's also important to note that police officers have a duty to protect and maintain public safety while also ensuring that individuals' rights are respected. Police officers should not use their authority to silence or discourage free speech or peacefully assembly. And they should not act to interfere with or inhibit these activities unless there is a clear and immediate threat to public safety. In the event that a police officer is found to have solicited a trespass against someone in a federally protected activity, they may be subject to disciplinary action and may also be held liable for any damages caused by the trespass. It's also worth noting that the individual who committed the trespass may also be held liable for any damages caused by their actions. Deprivation of rights under the color of law, violation U.S. Code 18242, which makes it a federal crime for any person acting under the color of law to willfully deprive an individual of their constitutional rights. Section 1983.
Okay, so first of all, Chili was at a gas station, and gas stations are private property. It doesn't matter if you're in the parking lot, at a gas pump, or inside of the store. The gas station is private property. In some cases, the strongest defense to NRS 207.200 charges is the right to free speech under the First Amendment of the United States Constitution. He has that correct. However, free speech factors in only when the property at issue is a public forum, such as a street or a sidewalk, not the parking lot of a gas station, not inside a courthouse or city hall or whatever. Streets or sidewalks. Can you be trespassed from a public place? You absolutely can. You can be guilty of trespassing in a public space even if you are allowed to enter a place that's open to the public, such as a store or a park. You can still be convicted of criminal trespass if you stay after the space closes or you fail to leave after you're ordered to do so. Who can trespass? An owner, occupier, in law occupation of the place or land may warn a person to leave that place or to stay off the place. The lawful occupier may authorize any other person, including a member of the police, to give the trespass warning. So if the police say, "Do you want him trespassed?" they can say yes. At that point, they're leaving it up to the police officer to issue the trespass warning. Just like if they call the police and the police show up and they say, "I want him trespassed," then the police officer can issue the trespass warning. There is no law stating that a police officer cannot solicit a trespass. Now, what Chilli is reading, okay, it took me a while to find this. But everything he was reading was correct. He was reading it right off of what he should have been reading. However, okay, US 18, Section 242 is deprivation of rights under color of law. This only comes into play when whoever under color of law, statute, ordinance, regulation, or custom willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured as protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account, here's the important part, of such person being an alien or by reason of his color or race than are prescribed for the punishment of citizens shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years or both. If death results from the acts committed in violation of this section, or if such acts include kidnapping or a attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title or imprisonment or imprisoned for any term of years or life or both, or may be sentenced to death. Okay, so US 18, Section 242. It's about civil rights, basically color, race, your sexual orientation, and your immigration status. The biggest thing is this covers death or injury. So what he's reading this off, but he's leaving this out. Okay? He's leaving this part out on purpose because he wants people to think that he found this golden rule that as long as you are acting or exercising your First Amendment rights or constitutional rights, then you can never be trespassed. And it's law, or it's wrong. 242, yes, you can take somebody to court, or a family member can take somebody to court if somebody acting under the color of law trespassed said person and it resulted in because of their color, their sex, or their race, or their immigration status, and resulted in injury or death. This has nothing to do with these idiots going out, First Amendment auditing, causing disturbance of the peace, disorderly conduct, and all kinds of other crap, and being trespassed. It took me a while to find this, but I know his game. This part right here says it perfectly. In which situation is prosecution under the federal statute 18 U.S.C. section 242 most likely? Answer: 242 increases when the crime leads to injury or death, or when it involves kidnapping or a dangerous weapon. So, yeah, this does not fit anywhere with what auditors do and when they are trespassed while doing what they do. But Chilli wants you to think so.
In total. So now, it, it, that's constitutional law scholar 101 right there. Cops cannot violate your constitutional rights to be press and solicit a trespass against you. I know this to be factual. Now, I'm a little rough around the edges and I'm pretty hardcore. So when I'm in the moment like that at the gas station, when that copper was annoying me, clearly you can see that I'm so bewilderedly mad and upset that this tyrant doesn't know the law. That I'm losing my I'm literally just going, that's illegal, honey. That's illegal, you know? And people are commenting on the video and saying it's not illegal to solicit a trespass. Clearly it's illegal. And so
Rough around the edges? No, you're just plain out wrong. And you're definitely not hardcore. That is a definite. And I can say that for a fact. You're a sensitive little flower petal. Because the minute anybody says no to you or puts you in your place or tells you the truth, you literally unhinge. That's not somebody who's hardcore. That's just somebody who unhinges very quickly and easily. Your constitutional law scholar 101 means you are not educated on U.S. Code 18 Section 242 or any part of the law as it pertains to a crime committed by one of color by law and leads to injury or death, or when it involves kidnapping or a dangerous weapon. Proof that you can research anything you want, Chilli. However, you do not comprehend anything that you've read. The cop does know law better than you, and that's clear. Because again, it's not illegal for a police officer to solicit a trespass. You read it, you read anything, but you tend to leave out either the most important part or purpose because it doesn't pertain to your narrative, or you read it and you just don't comprehend anything you've read.
okay. So let me now also, here's the other one. It's perfectly legal for you to film in courts. You are allowed to film your court case, and I'm going to give you a bunch of court cases right now that you can look up if you want to film your court case. Here's the legality of you being able to film your court case. Richmond Newspaper Incorporated versus Virginia, 1980. In Richmond Newspaper versus Virginia, the Supreme Court held that the Sixth Amendment right to a public trial applies to criminal trials, and that the press and public have a First Amendment right to access criminal trials. Globe Newspaper versus Superior Court, 1982. In Globe Newspaper versus Superior Court, the court held that the First Amendment guarantees the press and public access to the pretrial proceedings of criminal cases. Press Enterprise Company versus...
Where Chilli is now talking about Richmond Newspaper versus Virginia, he's saying that the Supreme Court pretty much came out with that the press can record inside pretrial or trial, whatever it was. He's wrong. They shall only be used if they're allowed for the purposes and in the manner authorized by the presiding judge. Photography, video recording, audio recording, or video transmission or communication of any information using any media from inside the courtroom is prohibited without prior written authorization of the presiding judge. Anyone wishing to video, film, tape, digitally record, or take pictures of any court proceedings must first be granted permission from the district judge prior to the proceedings they wish to record. This includes all media. Authorized cameras and recording devices must be set up prior to the start of court. Richmond Newspaper, Inc. versus Virginia, 1980. Richmond Newspapers, Inc. versus Virginia. Criminal trials must be open to the public unless there is evidence to support an overriding countervailing interest. Here's the important thing to realize. In Richmond Newspapers, Inc. versus Virginia, 1980, the Supreme Court ruled that the First Amendment generally prohibits closing criminal trial proceedings to the public. It says you can attend the trial. That's the only thing it's saying, is that the public and the media can attend the trial. It is not saying that you can attend and record the trial. In no way is it saying that.
Press Enterprise Company versus Superior Court, 1984. In Press Enterprises versus Superior Court, 1984, the court held that the First Amendment guarantees the press and public a right to access to preliminary hearings in a criminal case.
Glow's Newspaper Company versus Superior Court, 1982. Although the right to access criminal trials is of constitutional stature, it is not absolute, but the circumstances under which the press and public can be barred from a criminal trial are limited. The state's justification in denying access must be a weighty one. Where the state attempts to deny the right of access in order to inhibit the disclosure of sensitive information, it must be shown that the denial is necessitated by a compelling government interest and is narrowly tailored to serve that interest. Facts. Appellant Globe Newspaper Company sought access to a rape trial where the alleged victims were minors. The trial court denied access, relying on Massachusetts general laws, Chapter 278, 16A, 1981. Chilli is now going to tell you where the media was told to turn over unaired footage of police officers and like getting into an altercation with teenagers. It has to do with a case where several very young, and I believe it was between the ages of 12 and 14, teenage girls who were meh, and the information within the trial was extremely sensitive. And the media was told they could not record it. When they did record it, the judge ordered them to turn over this unaired footage, which they had every right to do. Chilli is wrong. None of this is stating that you can go in and record trials. All it's saying, every single case law he brings up from here towards the end, or here from here to the end, all it's saying is that the Supreme Court gives the media and the public the right to attend or access these trials. Accessing a trial means attending, being there, being present, watching it. Nowhere does it say that they have the legal right to record these trials.
Brazenberg versus Hayes, 1972. The Supreme Court held that the First Amendment does not give journalists a right to refuse to testify before a grand jury regarding criminal conduct they observed while gathering news. These cases indicate that the First Amendment does give rights to access to the press and public in criminal proceedings and information, but it does not apply to crime scenes.
Okay, yes. In Brazenberg versus Hayes, 408 U.S. 665, 1972, the Supreme Court ruled that the freedom of press did not create a constitutional privilege, protecting reporters from having to testify in a grand jury proceedings about the identity of news sources or information received in confidence. Again, where does it say that they have the right to video record the trials? Nowhere.
The case of Richmond Newspaper versus Virginia, where the Supreme Court ruled that the Sixth Amendment right to a public trial applies to the press and to the public. The case arose around the court in Richmond, Virginia, ordered the courtroom closed during the trial of two individuals charged with murder and prohibited the press from publishing any information about the trial.
In a 7-1 decision, the court held that the right to attend criminal trials was implicit in the guarantees of the First Amendment. The court held that the First Amendment encompassed not only the right to speak, but also the freedom to listen and to receive information and ideas. The court also noted that the First Amendment guaranteed the right of assembly in public places such as courthouses. The court emphasized that certain unarticulated rights were implicit in enumerated guarantees and were often indispensable to the enjoyment of rights explicitly defined. Basically, the only thing that they won out of this was the fact that the media and the public had the right to attend. They had the right to attend trials. They have the right to gain information. That's why most news media, when they go into these court trials or these courtrooms for like trials and stuff like that, murder trials and stuff like that, they go in with notepads and a pen. They don't record because they can't record unless the presiding judge allows it. So where Chilli is saying that all of these case laws are proving that you're allowed to record in courts, he's absolutely wrong. I don't see how he is misunderstanding these case laws. I just don't. I don't get how anybody could misunderstand the fact that you can attend or access a public trial versus you can record the public trial. Like, that's, he either is that stupid where he's not understanding anything that he's reading, or he understands it but he's trying to put it into his narrative, so he's twisting the words around for his audience. And that, it could be one or the other. Either one is bad, but it's just ridiculous how he keeps doing this with these case laws. He reads them and then he twists them, or he reads them, leaves out the most important part, and then twists them so that it fits his narrative. And that's all he does when he reads off case laws. You could see his face right at the end of that last clip where he read off the information that basically said that they have the right to access or attend the trial. Nowhere in there did it say record. Obviously, he did not read these over before he made his video, because his look of, oh shit, I think I just said something wrong that proved me wrong, right then and there proves everything I've just said.
The court held that the order was unconstitutional and that the press had the right to protect their unaired footage under the First and 14th Amendment. This decision reinforced the principle that the press had a protected right to gather and report news, and that it is protected under the Constitution. You can film in any courtroom you want.
No, again, that is not what it means. It means that the media has the right to attend or access the trial, and then they can write down the information of the trial and report on it once they've left the courtroom. It does not mean they can record. I am now just convinced he's stupid.
In any courtroom you want. So the court case you want to cite is going to be the case of Globe newspaper versus Superior Court. And the other case you want to cite, if you want to film in the courtroom, is Richmond Newspaper Incorporated versus Virginia. So in both of those cases, you have Brasenberg versus Hayes, 1972. You have Press Enterprise Company versus Superior Court, 1984. I read those other two. So there it is right there. So...
No, again, you cannot just record in any courtroom that you want to. And go ahead and recite these case laws to anybody you wish to recite them to. I guarantee that person is going to be extremely happy that you gave them the greatest laugh that they needed that day. Court proceedings are usually not happy-go-lucky things. Like trials, murder trials, or any kind of trial or hearing is never a good thing. So usually lawyers and judges need a good laugh. So go ahead and, recite one of these case laws that Chilli just told you to, and tell them that it tells you that you have the right to record in the courtroom, and they're going to have the greatest laugh of their life.
To work. I'm doing something. I'm building the studio for Constitutional Law Scholar. I got to get this done. I want to teach you guys really where your rights come from. And that is what a constitutional law scholar is. Someone who can quote and cite and be able to recall without even thinking about where your rights, and this is where people get mad at me, but it's true. The Enlightenment thinkers, John Locke, Rousseau, Montesquieu, most of the Enlightenment thinkers said that your rights came from God. Now, I'm not a huge religious person, but the point is that is where the origins of our Constitution, our founding fathers are recognizing the Enlightenment thinkers and their philosophies that you have unalienable rights that you're born with that are given to you by God. So that's where that comes from. That's why when you guys hear me talking about God, it's because that's where it comes from. That's where our Constitution is based on. I mean, if you don't understand how religious the world has been for centuries and centuries and centuries, and that this has really have been the only time of religious freedom in the history of the world, the last 100 years, then you don't really understand history. And so that's why I'm going to teach it, so I can teach you. And you'll learn. And you'll be like, wow, I learned something I didn't know before. Cool, that's why I'm going to teach Constitutional Law Scholar. Listen, I got to get the flock out of here. So for all of the dunce caps who go into my comment section, this is a call to the Delete Laws Army. You go to the dunce caps in the comment section of the video I just posted, and let me tag a comment. Let me tag a comment. I'm going to pin a comment at the top. And this is the analysis that I just read. So let me find this comment, and I'm going to tag it at the top.
Okay, so there we have Chilli again reciting case laws that he doesn't understand when he reads them. He doesn't seem to comprehend them, or he does, but he's just trying to turn them into what fits his narrative so that he can continue manipulating all of his audience into believing what he believes. Because all of Chilli's beliefs come from his feelings and opinions, and that's it. He has no intellectual basis on anything he talks about. The only thing he is credible to teach is how to misinform on constitutional and case law to fit your opinion and narrative. That's about it. I mean, he's also credible on teaching how to lie, how to grift, how to use people, how to defraud people. Yeah, that's about it. He's not educated on constitutional law, so I don't know what he plans on teaching. He can't even teach history because he doesn't even understand that. He doesn't even understand natural law. And I will get into that in another video, but he does not understand natural law at all. So, yeah, I wanted to do this video just because it kind of goes in with yesterday's video. So when I saw this, I was like, ugh, it's long. I have to listen to his voice this long. But I'd rather do it so that you guys don't have to. With that said, I hope you enjoyed the video. I will see you in the next one. Take care, be safe, and I love each and every one of you.